everyone. We are going to start recording or start our presentation momentarily. Just wanted to make sure everyone who wants to get in has a chance to. Okay. I am going to turn this over to John in just a moment, and he will give the beginning of our presentation.
Good afternoon, everyone. This is John Bernatovich. I'm the president and founder of Willory. We're excited to have you on Willory's first ever webinar. As part of our commitment to the HR and payroll community, we've increased our efforts on presenting continuing education opportunities, and our plan is to continue to have webinars throughout the remainder of this year, with an in-person training session coming up in April 2017. You can stay up to date on our offerings by visiting willory.com/training. Today we'll be discussing the DOL's final ruling on overtime compensation and our recommendations. We hope this provides you with some more insight into the rule and the recommended actions. As experts in HR assessment and compliance, we're here to help you out if you need any additional information. I'd like to take a moment to introduce our panel of speakers. So our host, the voice you've heard already, is Bridget Klein. She will be taking any questions and also coordinating the general webinar. We also have Dave Vance, labor and employment attorney from Zashin and Rich, as well as Holly Hall, one of Willory's HR consultants. So take it away, Bridget, and thanks to all for attending.
All right, thank you everyone for being here today. I am going to put everyone back on mute. All right, so thank you, John. We want this webinar to be interactive, so we really are encouraging questions. So to ask a question, there is a chat bubble at the top of the Join Me screen. You can click on that, and in the towards the bottom of the option, there's an arrow and then the @ and all. Click on that arrow, hit admin, and you will be able to send a question directly to us. Additionally, after today's webinar, you will receive a follow-up email with the presentation and a survey. So, all right, let's get going.
Thank you, Bridget. Thank you, John. I want to start off by saying thank you to Willory for the opportunity to present. I've had the privilege of working with Willory for the last 3 to 4 years, and everyone from John all the way at the top to the entire organization is really top-notch. So for those of you that have not had an opportunity to work with Willory yet or on the fence about using Willory, I strongly encourage you to do so. So let's begin with a very basic, rudimentary overview of the Fair Labor Standards Act, because that's really what the Department of Labor's final rule is all about. The FLSA was passed way back in 1938. In short, it establishes a minimum wage, which federal minimum wage right now is $7.25. In Ohio, it's $8.10, and it also, the FLSA also set forth overtime requirements, which basically requires any non-exempt employee to be paid at time and a half for all hours worked over 40 in a work week. The FLSA also sets forth record-keeping standards, fairly exhaustive standards. Includes employee information, hour in the day the work week begins, what employee regular hourly rates are, overtime for the week, and a whole host of other things. Then really the crux of the Department of Labor's final rule impacts the classification of employees and whether they're exempt or non-exempt. And then finally, we're going to, or at least I'm going to hit some of the penalties for failing to abide by the FLSA. So let's talk about the changes in the FLSA.
Okay. So,
The how exactly did the changes come about? Well, the Department of Labor issued a final rule which it published on May 18, 2016. What exactly did the final rule do? Well, the most significant change was that it increased the salary thresholds under the FLSA from $23,660 a year to $47,746 a year for your executive, administrative, and professional exemptions, which are commonly referred to as the white-collar exemptions. And that put it at, that 47,746 number is the 40th percentile of earnings of full-time salaried workers in the lowest wage census region, which happens to be the South. It also increased, or will increase, the salary threshold for the highly compensated executive exemption from $100,000 to $134,004. The threshold for the white-collar exemptions more than doubled, so this is a significant change relative to your non-exempt exempt dichotomy.
So one of the questions we've had so far is, how do you determine whether someone is exempt or non-exempt?
Good question. Whoever presented that question, frankly, that could be a whole presentation in and of itself, so I will try and keep this short. Really, you're going to look at, when determining whether or not someone's exempt or non-exempt, you have to look at three separate tests: the salary basis test, the salary level test, and the duties test. The employee has to pass all three tests in order to be considered exempt under the FLSA. The first test, the salary basis test, you need to determine whether or not the employee is paid a fixed salary that is not subject to reduction due to variations in the quality or quantity of the employee's work. Assuming that is the case, then you're going to look at the salary level, and that is really where the Department of Labor's new rule impacts directly the FLSA. The salary level, you need to determine whether or not they meet the actual salary level. Currently, again, $23,660, going to be increased to $47,746. Now, keep in mind, and a lot of employers fall victim to this, they think that, all right, our employee is going to be making, as of December 1, which is the effective date, $47,746. That's not the end-all, be-all. Just because an employee earns or meets the minimum salary threshold does not automatically make them exempt. The final test, so you have the salary basis, the salary level, the final test is the duties test. The duties test is basically, you need to determine whether or not the employee is primarily involved in either executive, administrative, or professional duties. Very briefly, to discuss each one of the three, you've got your executive exemption. Under the executive exemption, the employee generally needs to be and have a primary duty of managing at least the equivalent of 2 full-time employees. In addition, the employee needs to have the opportunity or the authority to hire, fire, promote, or give their opinion as to those types of decisions. That's the executive exemption. Now you have this separate administrative exemption. That exemption, the primary duty needs to be the performance of non-manual or office work, which is directly related to the management of the general business operations. Really, it relates to the running or the servicing of the business. This is going to be your HR, your procurement, your safety and health employees are going to fall under this category. In addition, under the administrative exemption, the primary duty must include the ability to exercise discretion and independent judgment as to matters of significance. So it can't just be that the employee works in HR. The employee must work in HR, but they also must be able and have the authority to make significant decisions that impact the company. Finally, you have your professional exemption. This really falls into 2 buckets. You've got your learned professionals, which through a course of advanced study, they've received special instruction. That's going to include lawyers, accountants, engineers, pharmacists, and then you also have the artistic professional, which is going to include your composers, musicians, graphic artists, those types of folks. So those really are the exemptions. Again, keep in mind that it's more than just the salary. There's also a duties component. So where is this going to come into play, this new final rule? It's going to come into play basically everywhere. There are very few companies that fall outside the purview of the FLSA. It's estimated that an additional 4.2 million people are going to be protected by the FLSA's overtime protections as of December 1. That number in Ohio alone is estimated at over 133,000 people. So for those of you that are on this call, it's very, very likely that you have employees that are going to be impacted by this rule. When? December 1, 2016, that's when this thing goes live. So the last time the salary thresholds were updated were way back in 2004. In addition to the salaries being increased as of December 1, there's also a mechanism in place within the final rule to adjust the salaries every 3 years, with the first adjustment happening on January 1st, 2020. So keep that in mind too. Obviously, there'll be a great deal of information that comes out again at that time, I'm sure. So why exactly did this come about? Well, way back in 2014, President Obama directed the Department of Labor to update and modernize the FLSA. This final rule came about as part of that directive. Clearly, I think most everyone would agree, or by and large, most folks agree that it was time, given that the last increase was back in 2004, to increase the thresholds. Whether or not everyone agrees that they should have increased as much as they did is probably a different argument, but one that is immaterial at this point, because these are the thresholds and this is what we need to operate under. So with that, let's discuss why the changes matter. Well, they matter to employers for a number of different reasons. First, different can be difficult, as I'm sure you all know. For employers, if you're going to change somebody from exempt to non-exempt, that means you're going to have to potentially pay them different. You're going to have to track their time. You're going to have to manage additional employee schedules. When somebody's exempt, they don't have a schedule necessarily. Whereas if they're non-exempt, they're going to have a schedule. They're going to be expected to be in the office or in the work environment certain hours. So that's going to be some things that employers are going to have to deal with that they have not had to deal with in the past. For employees, for those that are going from exempt to non-exempt, they too are going to have changes. They're going to have to track their time now, potentially. They're going to have to log their hours. When did they work? When did they not work? There's also the emotional impact of, if I'm no longer a salaried worker, have I lost prestige within my workforce? And these are all things that employers need to take into consideration and think about when evaluating what to do about this new rule. You've got a better educated workforce as to this change. As you might expect, there's been a great deal of news coverage about the change. So your employees know this is coming. They're preparing for it. They're thinking about it, particularly those employees that are sitting in that $23,660 to $47,746 window. And they're thinking to themselves, okay, I'm getting a raise or something's going to happen. And they know it's supposed to happen December 1st. And if it doesn't happen December 1st, they're going to come talk to you, or they're going to go talk to a plaintiff's attorney. So let's try and avoid that, and I think this is a great first step to doing that. It may very well impact your benefits. This Department of Labor rule could very well and likely will impact your benefits, and that ranges from, what benefits you offer to potentially if folks are being transitioned from full-time to part-time to salaried to non-salaried, even things that you might not think of, like the use of a smartphone. So your exempt employees might use a smartphone, and they're emailing folks at all hours of the night, 8, 9, 10 o'clock, or before they come to the office in the morning at 5, 6 when they wake up in the morning. What are you going to do now when that exempt employee now becomes non-exempt? Are you going to take that smartphone away from them so they can't make those emails and they can't perform work during off hours or when they're not technically clocked in? And then the alternative, if you're going to allow them to keep that smartphone, how are you going to track those hours? Are you going to say you can't email folks between or check your email between these non-work hours? Or what are you going to do? Are you going to then penalize people if they are emailing during those hours? These are all things that employers need to think about that I know Holly's going to get into. Penalties. Penalties can be significant. There are two ways for the FLSA to be enforced. One is the Department of Labor may investigate your company directly. If they're not satisfied with the outcome of the investigation and your response to that investigation, they very well may file a lawsuit in federal court. That's option one. The other option is an employee or collection of employees may go to a plaintiff's attorney, and that employee or that collection of employees will file a lawsuit against your organization. In that case, you're looking at significant monetary. In either instance, you're looking at some sort of monetary payout. But in the case where you've got a private attorney and a group of employees filing an action against your company, you're looking at if it's a unwillful violation, 2 years of back pay, or if it's a willful violation, 3 years of back pay, and then liquidated damages. And in essence, your liquidated damages is just going to be double whatever your back pay amount is. So if your back pay amounts, say $300,000, you tack on an additional $300,000 for liquidated damages, and you're already at $600,000. That doesn't include the mandatory attorney's fees. Mandatory attorney's fees, which will be levied against you, attorney's fees in a case like this, if it resolves itself relatively early, may be as little as $25,000. If you go all the way to trial, you could be looking at anywhere from $100,000 to $200,000 in attorney's fees. So the penalties and the damages for this are significant, particularly given that Department of Labor and that private plaintiffs' attorneys have already been targeting the FLSA, particularly private attorneys, because of this mandatory attorney fee provision. So this is why we're really encouraging, and I'm encouraging all of my clients to seize this opportunity. Again, the last time the salary thresholds changed were in 2004. Since that time, there hasn't been a good, what I would call, excuse to change someone from exempt to non-exempt. When I go through and perform an audit of my client's workforce, and there'll be folks maybe that should have been non-exempt that are classified as exempt, the struggle is always, well, now what do we do with this person? How do we change this person from exempt to non-exempt? Because inevitably that person or that collection of employees is going to want an explanation. Well, why did I used to be exempt and why am I now non-exempt? And it's always a struggle. What do you say to that person? Do you tell them that we misclassified you and try and offer them some sort of monetary amount to make them whole, so to speak? Do you just do it and try and hope that they don't come back on you for 2 or 3 years and then you're outside that statute of limitations? What do you do? Well, here we have a built-in reason. We can point to the Department of Labor's final rule effective December 1, 2016 as the reason why we're transitioning you. And employees are going to be less likely to scrutinize past practices when there is a valid reason for the change. So seize this opportunity. Try and make this a positive for your organization. When you're changing somebody from exempt to non-exempt, talk about how their salary is going up. Talk about it could be an opportunity for overtime, or that it could improve their work-life balance. Accentuate the positive. And I really urge you to look at all of your exempt employees, not just a handful. Look at all those that are exempt, even those that are exempt and that are already over the salary threshold. And take a total look at this exemption and where you sit today and go forward from there. And make sure you do this now. Again, we're only 4.5 months away.
Okay, so we have had a couple questions come up. So just to clarify, do the changes have to occur by December 1st, or can they be working towards a resolution by that point?
This goes effective December 1, so this needs to be resolved, and you need to have your employees transitioned as of December 1 if that's what you intend to do.
Okay, thank you. And then is there any chance this might not go into effect?
At this point, I would say no. This is too far down the road that I would be shocked if there was an about face. Even if, say the Republicans take the presidency, it's not, Obama's still going to be there. The Democrats are still going to hold firm to this. So I don't see this changing.
Okay. Well, thank you so much for talking about the law itself. We are now going to transition to Holly to talk about some of the recommendations.
So thank you, Bridget, and good afternoon, everybody. David has provided you with an overview of the new rules and regulations that are going to go in place. So I'm going to actually discuss some areas you need to consider as you implement these new rules. And so one of the big questions I'm sure people are asking is, where do you begin? The first thing you want to do is you want to be prepared and create a plan. So this plan would take into consideration all different elements of your HR practices that would be impacted by these changes, not just the salary change alone. So you need to make sure that you're thinking about all those different components of what you're going to review and consider as you look at reviewing your organization. The second thing is become educated on the new law to better understand what's involved. I mean, David gave you a great overview of that and understanding. There is also a lot of information on the DOL website that provides further information as well. There's fact sheets and things of that nature. Conducting FLSA reviews should be done, can be done, and probably should be considered to be done under attorney-client privilege. And so what does that mean? So I'm going to have David talk a minute about that.
So in a perfect world, and if money was never an issue, it would be ideal for your organizations to have your FLSA reviews done by an attorney, because that keeps the review protected by the attorney-client privilege. And say, for example, you conducted an exempt, non-exempt audit, and you determined that a significant group of employees has been misclassified. Your organization has misclassified a group of, say, 20 employees for the last 3, 4, 5 years. If that's done by an attorney, you can protect that audit and you can protect those findings. If your company does that internally, it's very, very difficult to keep that protected. If there were to be, say, one of those 15, 20 employees were to bring a lawsuit against the company, all that information, all your audit materials, all of your findings would be discoverable. And in essence, that plaintiff's attorney would basically go to the court and say, here, look at what the company determined itself. They goofed. Here's the evidence of that. So for that reason, I suggest where you can and where it's feasible from a financial standpoint to have an attorney do this. Obviously, that's not always the case. So what I would suggest, if you're concerned about specific groups of employees, maybe you have a particularly large group of a certain employee, maybe it's assistant managers, or maybe it's even managers, and you're most concerned about those folks, maybe that's when you pick up your phone, you call your attorney, and ask them to take a look at that for you. But for your lower level folks, or for the folks that you're less concerned about, or the groups you're less concerned about, it's more than okay to do this yourself. Just be very, very careful and caution the people that are looking into this as to what they put in writing. So I'll turn it back over to Holly.
Thank you. So the next thing is to understand the options included in conducting a review. So the DOL has provided some options for consideration, which I will discuss in a moment, but they are something that you want to make sure you incorporate into your plan. The next is determine what impact this will have on current practices, policies, and procedures. So if you have, for example, in a company that has all salary designation today or exempt designation, what policies or practices are in place to support those kind of changes when you have moving some of the folks to non-exempt? So you'll want to look at all of those. And then the other thing you need to consider in your plan is consider the type of communication and training that you need to do for your managers and your employees. That's going to be a critical component in making sure your managers are educated, so that when questions are asked of them, they're able to respond. And if they don't know an answer to that, they know who to go to get the answer instead of trying to guess, which we know happens sometimes. So that's an overview, and we're going to go into a little bit more detail on that. So what are the options for employers? Again, there's 4 different options that the DOL provides guidance on. The first one is you can raise salaries to the exemption threshold. You have that ability to do that. And if you do, you need to understand that you're going to incur some additional costs for the employee. So for an example, if you have somebody who's making $40,000 a year and you want to raise it to the new threshold of $47,476, you're going to automatically add $7,476 a year to your operating costs. So that's just one employee. So you really need to think about, when you look at your entire population, what method you want to use here. The second one is to reclassify effective employees, but don't limit overtime. Obviously, this is an area where it's going to be critical to understand how many hours are the employees working, so they can set the new pay. But it does not allow for controlling overtime costs in general, or the amount of overtime an employee can take. So, but it is an option that you can consider. The third option is to reclassify effective employees and prohibit overtime without authorization. This will help likely reduce the number of hours that some employees work, and it may also impact the workload and getting that work accomplished. So this is actually, but if somebody does work overtime and it's not authorized, in this scenario, you could, you'll still need to pay the person for that time, but you could impose disciplinary action upon them. And that's something you want to make sure that's included in your policies in doing so. This is really probably the recommended approach that we would have of those two scenarios for most employers, is to really limit the amount of overtime. And then the last one is you can evaluate and realign the employee workload. So looking at, you know, what does your workload look like today? What is some work that maybe can be shifted around to other positions? Or can you discontinue work, or is there unnecessary work? Those are all things that you can look at, or you may decide to outsource some work. So there are some options under that scenario as well. So in the considerations, which costs will help you optimize your FLSA labor costs? You know, option A is start paying overtime, and what are all the things that are involved with that? Or option B is you increase employee salaries, and looking at the two of them to determine the overall cost.
We have a question about what determines a work week. Some organizations have a 37.5-hour work week. So is overtime only over 40 hours?
Yes, overtime is only 40 hours in a work week. So if they have a lesser period, then obviously that's...
They have some grace.
Yes.
Okay.
Yes.
And the FLSA doesn't require or doesn't prohibit an employee from working any set number of hours per day. Or, you know, if you want to have somebody work 4 10-hour days, that's more than fine. The key is the 40 hours. And the FLSA requires that you set when your work week begins. So while you may have a work week of only 37.5 hours, there needs to be some set time that work week begins. Is it at midnight on Sunday?
Mm-hmm.
Is it Monday morning at 8 a.m.? You have to put that in writing and keep a record of that.
Mm-hmm. Right. And then the other thing you have to keep in mind is the job duties rule for above the new threshold. Just because they're above that doesn't mean that there's a job duties test and the professional exemptions that you have to look at in consideration with that. So the next one is how do you look at your employees in doing this review and their exemption status? So one of the first things I would recommend you do as part of your plan is that you pull all salary and incentive pay data for all your employees, and review all of that and determine who's within the threshold, who's above the threshold. Also, what kinds of job descriptions do you have on file? Are they up to date? Are they something where you need to revise them or look at your qualifications for that to making sure they're current, because that's one of the things that you would look for to use for the job duties test and establishing standard job requirements. The next one is to review compensation practices, and that would include what impact would these compensation practices have on the changes that you're going to be making. Are you calculating overtime properly? If you've never calculated it before, how do you do that? What's the right method to do it? And there is standards around how you're supposed to pay that overtime. Benefits, as David mentioned earlier, there could be some differences there in looking at your benefit plans. Do you have? It's less likely with ACA now to have exempt and non-exempt differences, but is there something within any of your benefit plans that could impact you with this new rule? And then the last thing is to look at revising or creating policies related to timekeeping. So if you don't have those in your handbook, your policies today, you should be thinking about incorporating those and what that looks like. And then any timekeeping or reporting systems that you have, are you able to report non-exempt time?
Ooh.
Then just a quick overview on the highly compensated executive. Basically, you just need to determine what employees fall into the new threshold. That's pretty simple with using the salary test. But then making sure you're reviewing benefits package, as noted previously. There could be things where you're doing something different with a highly compensated employee, and now you're going to have people who are not going to be in that category. And if that is the case, what do you do with that?
And keep in mind, too, with the highly compensated executive that they do indeed need to meet the new threshold, but they also have to perform at least one of the duties of the executive administrative professional. So, for example, if you're going to say the executive, as a reminder, they have to not only manage 2 or more full-time employees, they also have to exercise some level of authority or significant level of authority relative to hiring and promotion, those types of decisions. Under the highly compensated executive, so long as they manage the 2 or more full-time employee equivalents, that's enough. They don't need to also be able to hire, fire, so on and so forth. So it's just one criteria of any of the 3: administrative, executive, or professional.
Okay, and then training and communication. So I talked about this in the beginning. So you want to train your managers before your impact employees to prepare them for questions. I would even go to the point of using scripted talking points to ensure the message is consistent, particularly if you're going to have multiple people who are going to be delivering the message. You want that message to be consistent, and then that script would be used to communicate those changes to the impacted employees. Also with impacted employees, I would say my recommendation is that you do them on an individualized basis, because everybody's going to have what's in it for me, and you're going to want to be able to speak to that versus doing it as a group. And it's just, I think it's a better message to be able to speak to them on an individualized basis. Then once you communicate with everybody, you're going to want to train these classified employees in the new timekeeping requirements and policies that you've developed and created as a result of that, and what that means to them, from travel time to how they record their time. Those kinds of things should all be part of that. And then any training that you provide, we should be tracking and recording. So if you put a presentation together, you should keep that presentation, record and track who's attended, so that is also used in case you're challenged. So in order to start executing this, one of the recommendations we have is you can start tracking hours now for those who are below $913 a week without having the actual employee, track this for you. So there's a couple different ways to do this. You can have managers begin tracking hours. They should pretty much know somebody's schedule and what kind of hours they are, and if they're doing some stuff remotely at night and those kind of things, so that you should be able to do that and get fairly accurate records on that. You can use a computer log-in, log-off process, so you can go into the company systems and look that way. And then if you have a swipe card system any kind, then you should be able to pull records and, again, see some of that tracking as well. So that would start giving you some indication about the kinds of hours that the people are working today. And then, again, I would emphasize creating a plan, as I mentioned at the beginning, on what's going to be reviewed, and a lot of these elements would be some of the things I would propose that you put in there. And then making sure you document how decisions are made. That's going to be a very important part of this as well, that you want to make sure in your exemption classification, that you're explaining how you came to. So just a couple other points here. So just a reminder that job titles alone never determine the exemption status. Job duties, tests, and other things you've got to take into consideration. And that receiving a particular salary does not indicate the employee is exempt from overtime and minimum wage. Again, just make sure you're doing your due diligence and review. And if you're uncertain, as David mentioned earlier, you need use your attorney for advice if you're not particularly sure what you should be doing in a particular case. So just in closing, just don't put this off. Start your plan now, because 12/1 is going to get here before you know it. Thank you.
Okay, so we did have one additional question. With certain laws, such as FMLA, businesses under a certain threshold of employees are not required to follow the same restrictions. Is that a case here, or is it all businesses, no matter their size?
By and large, it relates to, the FLSA relates to businesses that are involved in what's called interstate commerce. So it's a very, very broad definition. If you've got 2 employees, you're involved in interstate commerce, the FLSA is going to apply to you. There's only a handful of companies that the FLSA does not apply to. Frankly, if you think you're one of those companies, give me a call and I'll be happy to talk to you about that. But chances are you're going to fall under the purview of the FLSA.
All right, thank you. So on behalf of Willory, we want to extend a sincere thank you to David Vance and Zashin and Rich. They are a law firm built on wealth of knowledge, experience, and commitment to serving their clients. Since its founding in 1981, Zashin and Rich has established itself as a leader in Ohio workplace and family law by continuing to expand and adapt its clients' changing needs. They pride themselves on client satisfaction and innovation and growth. So, thank you once again.
Thank you.
We are all here to help you with any additional questions you may have. As previously mentioned, I will be sending an email out with the presentation, and you are free to respond to that email with additional questions. I will feed them to everyone. Contact information is also right here. So we appreciate your attendance, and thank you so much for attending Willory's very first webinar.